Good afternoon, everyone. I will start by introducing myself. I am Éric Lavallée-Stache. I will be the moderator today, and I would just like to say a few words about how things will go. Chief Justice Moreau will come into the room shortly, and she will place her things on the desk, and then she will go around to welcome everyone.
To you very briefly how things are going to unfold before we begin. Chief Justice Moreau is going to be arriving very shortly. When she arrives, she's going to come to her desk first and leave her things, and then she'll go around the table to shake hands with all of the participants in the hearing. So I will let you know when she's arrived and ready to enter. Thank you. I'd ask you all for your attention once again, please. Join me in welcoming Chief Justice Marie Moreau. Veuillez me joindre pour accueillir l'adjudant en chef.
Please join me in welcoming Chief Justice Marie Moreau.
Members of the House of Commons and Senate, students and other guests, and all Canadians who are listening and watching remotely, I wish you welcome. We are gathered here in Ottawa on the unceded territory of the Algonquin people. We thank you for joining us. Je m'appelle Éric Labelle-Istaffe.
My name is Éric Labelle-Istaffe. I am a professor and dean of the law faculty at the University of Moncton. I have the very great honor of being the moderator here today for this discussion between the Honourable Chief Justice Marie Moreau of the Court of King's Bench of Alberta, the candidate proposed to be appointed to the Supreme Court of Canada, and the members of the Standing Committee of Justice of the House of Commons, and the members of the Standing Committee on Legal and Constitutional Affairs of the Senate, and a member of the Green Party of Canada.
I wish to acknowledge the presence of the following individuals. First, the Honourable Wade McLaughlin, Chair of the Independent Advisory Board for Supreme Court of Canada Judicial Appointments. Shailene Curtis McAuliffe, Deputy Minister of Justice and Deputy Attorney General of Canada. Jean-François Fortin et Isabelle Jacques,
Jean-François Fortin and Isabelle Jacques, who are both Deputy Ministers of the Department of Justice of Canada, and Mr. Giroux, the Commissioner of Judicial Affairs.
Interpretation is available during this session. You can adjust the settings by clicking on the interpretation icon at the bottom of your screen if you are watching online. The Supreme Court of Canada is Canada's final court of appeal. It decides legal issues of the utmost importance for all Canadians in many areas of law. La nomination d'un juge à la Cour suprême est donc un événement.
The nomination of a judge to the Supreme Court is of great import for the judicial system and constitutionally, and because the Supreme Court is responsible for making decisions on matters of extreme importance to Canada, but also of ensuring the balance between the legislative branch and the judicial branch, and also protecting the human rights and freedoms. Our Supreme Court is respected worldwide. It is recognized for its independence and the excellence of its justices.
Responsibility that lies upon judges of the Supreme Court of Canada, it is crucial that a rigorous process be followed. In this case, the process was launched by the Prime Minister of Canada on June 20th, 2023, following the retirement of Justice Russell Brown. Justice Brown was appointed from the Alberta Court of Appeal, and so in recognition of the Convention of Regional Representation, the process was open to candidates from Western and Northern Canada. Since 2016, this process involves the creation of an independent, nonpartisan advisory board whose mandate is to provide a short list of candidates to the Prime Minister for Supreme Court appointments. Cette année, le comité consultatif.
This year, the advisory board was chaired by the Honourable Wayne McLaughlin, the former Premier of Prince Edward Island. It was made up of the following people: Ms. Carol Ann Lee, Ms. Georgina Nagano, Bianca Kratt, Erin Kleisinger, the Honourable Richard Chartier, Ms. Dean Reem Badi, and Jean Tayet.
Conducted an evaluation of the candidates based on the criteria released by the Prime Minister. This long list of criteria includes a superior knowledge of the law, superior analytical skills, the ability to solve complex legal problems, an awareness of and ability to synthesize information in the legal context in which legal disputes arise, clarity of thought, ability to work under time pressures in any area of law, a commitment to public service, irreproachable integrity, a respect for others, moral courage, discretion, and an open mind. De plus, afin de répondre aux besoins institutionnels.
Furthermore, in order to meet the institutional needs of the court, the government committed to only nominate justices who are functionally bilingual and have a balance between their knowledge of public and private law, and also to ensure that the court reasonably reflects the diversity of Canada.
List of eligible candidates. And on October 26th of this year, Prime Minister Justin Trudeau announced the proposed appointment of the Honourable Mary Moreau, currently Chief Justice of the Court of King's Bench of Alberta, to the Supreme Court of Canada. Justice Moreau's appointment would truly be an historic moment for Canada, as it would mark the first time women were in a majority on the highest court in the land. Lors d'une audience spéciale qui a eu lieu plus tôt ce
At a special sitting that took place earlier, the Minister of Justice and Attorney General of Canada, Mr. Virani, as well as the chair of the advisory board, appeared at the Standing Committee on Justice of the House of Commons to discuss the selection process and the reasons for the nomination. But the nomination process also envisages a public exchange of views between the candidate and parliamentarians, and that is why we are here today. The purpose of this exercise is to enable parliamentarians and, in fact, all Canadians who are listening to get to know the proposed candidate. It is their chance to learn a bit more about her professional and personal experiences that have led her to this point here today.
Proceedings are to be conducted in the highest tradition of civility, respect and restraint, being mindful of the importance of the principles of judicial independence and impartiality. While Canadians, through their elected representatives, must be able to participate in democratic decisions, they must also rely on a judiciary that can make decisions free of influence and based on fact and law. Thus, in the exchange that will follow, parliamentarians should not ask the nominee to comment or take position on issues that may be pending or may arise before the Supreme Court, in order to avoid that she be perceived as having a pre-established opinion on such questions. Bien qu'il soit parfaitement acceptable de questionner la candidate sur ses réponses au questionnaire,
the candidate may be asked about her answers in the questionnaire with regard to, for example, her view of the relationship between the Supreme Court and other branches of the government, and with regard to the interpretation of particular laws or regulations or hypothetical situations that would be debated at the Supreme Court. That is not allowed.
Not ask the nominee to comment on previous decisions of the Supreme Court or to comment on or to justify her own past decisions. J'insiste sur le fait que cette séance ne se transforme pas en un contre-interrogatoire.
This should not be a cross-examination of the candidate, and it is not the time to question decisions that she has rendered in the past or could take in the future.
The candidate should not be asked to comment on the nomination process itself. J'invite plutôt les parlementaires à profiter de.
I would invite parliamentarians to take advantage of this extraordinary opportunity to exchange views with Justice Moreau to learn more about her and the role that she will be asked to play.
The question does not respect the delicate balance between democratic participation and judicial independence. I will ask the participants to reformulate their question in such a way as to be consistent with the Chief Justice's duty of restraint, or to ask another question. This may mean that some questions will not receive answers or only partial ones. I thank you in advance for your cooperation. La séance se déroulera comme suit.
Justice Moreau will first give a presentation that will last about 15 minutes. Then I will ask members of the House of Commons and senators to ask questions in the order that was set in advance. Parliamentarians are asked to wait until I call on them before taking the floor.
This is not a regular meeting of the House of Commons or Senate standing committees, and as such, parliamentary privilege does not apply to this special hearing. Finally, please note that in light of the large number of participants, parliamentarians will each have a maximum of 4 minutes to engage in a discussion with Chief Justice Moreau. And to be clear, those 4 minutes include the question or questions and the answer or answers. There will be a timer in front of you that will indicate how much time you have remaining in what has been allotted to you. I'll be responsible for keeping time, but I'm sure I can count on each and every one of you to help me discharge that particular duty. Une fois que les parlementaires auront été entendus, la candidate.
Once parliamentarians have been heard, the candidate will be asked to make very short closing remarks before I end the hearing. So I now have the immense pleasure of introducing Chief Justice Marie Moreau, who is nominated to be appointed to the Supreme Court of Canada. Thank you, Dean Labelle-Estaffe. Members of Parliament, senators, distinguished guests. I wish to thank the Prime Minister for the great honour of having been chosen as a candidate for the Supreme Court of Canada. And I would like to thank the Minister of Justice and all of the members of the advisory board chaired by the Honourable Wade McLachlan, who assessed my candidacy. The Commissioner for Federal Judicial Affairs, Mr. Marc Giroux, and the staff in his office assisted me greatly in all of the steps following my selection as a candidate, and I would like to thank them as well. It was with a great deal of humility that I present myself here before you today as a candidate to become a Supreme Court Justice. I'm here to talk a bit about myself and to answer your questions. I would also like to take this opportunity to recognize the immense contributions that Supreme Court justices of the past and of the present have made. I am the sixth child of a family of 8. My father's father was born in Quebec, and he went to Hoy, a little town in Saskatchewan, to work as a doctor. And it was a town with a concentration of French Canadians. And that is where my father, Joseph Moreau, was born. Joseph went and studied at the Jesuit College and then studied medicine in Edmonton. My maternal grandfather was an RCMP officer in southern Alberta. My mother was a nurse with Irish and Scottish blood. My parents got married before my father went on to study orthopedics in French in Montreal. My dear parents have passed, but despite that, I strongly feel their presence today. From the very start of my schooling, I was educated in bilingual schools. They are called immersion schools now, and at the time, only 50% of classes were given in French. Francophone schools did not exist in Alberta at the time. As a member of the separate school board, my father fought to increase the number of classes offered in French in Alberta. Today, Alberta has more than 40 Francophone schools, and I am very proud that one of them in Edmonton is named after my father. It's called École Joseph Moreau. French-Canadian language and culture have always occupied a very important place in my life. My father loved to sing, and he taught us the lyrics of voyageur songs so that we could sing them on long car trips, and I still like singing them. My family liked to go to the Sugar Shack, and we'd go to plays in French, and my English-speaking mother even learned how to cook typically French-Canadian dishes, but she had a tendency to rename them. So her split pea soup became Irish soup. But she always encouraged us to continue to study in the language of our father in French. My first 2 years in university were spent taking science and arts classes at the Saint-Jean campus, a multidisciplinary francophone faculty of the University of Alberta.
Mes études ont été très importantes en ce qui a trait
undergrad philosophy courses taught by le professeur Laurent Godbout at the Campus Saint-Jean. He introduced to his students, in his Socratic style, the rigor of critical analysis, of studying an issue, like turning a prism to view all of its facets. His lessons were most helpful in my judicial career when regularly called upon to decide between two perspectives, while recognizing their many often subtle nuances. Le professeur Godbout encourageait par ailleurs ses élèves.
Professor Godbout encouraged his students to always attempt to find the right word in French to maintain the quality of French in a majority English-speaking milieu.
University of Alberta Faculty of Law, and have been touched by all the warm wishes on my nomination from my classmates. While attending law school in an English language environment, I was able to improve my written and oral French as a summer relief news writer and reporter for Radio-Canada in Edmonton, and in an 8-week summer program at l'Université de Sherbrooke studying le Code civil du Québec. I was fortunate to be able to practice in Edmonton for 14 years in my first loves, criminal law and constitutional law, mainly focused on language rights. official language rights, and also in civil and family law litigation. Turning to my family, I met and married my husband, Peter Royal, KC, a criminal defense lawyer, now retired, and we had our 4 children, Joe, Pierre, Émilie, and Paul, during the hectic early years of our respective law practices. I would not be here today without that strong support and love from my family. Despite their mother's tendency to helicopter over them, my kids are each following their own paths, and Peter and I are very proud of them. And our family happily awaits the arrival of our first grandchild on December 25th, as a matter of fact. Durant ma carrière d'avocate, j'ai plaidé en français.
As a lawyer, I argued in French at the Supreme Court of Canada with regard to the right to a jury trial in French in Alberta in the Paquette case, and to the right to manage and control French minority education institutions in the Mahé case. With the support of Michel Bastarache, before he was appointed as a Supreme Court Justice, I was involved in a number of cases linked to negotiating language rights in Alberta, British Columbia, and Saskatchewan. During that time, a group of Franco-Albertan colleagues, including Louis Desrochers, Pierre Desrochers, Denis Noël, Pierre Lamoureux, my friend Jean Moreau, and myself founded the Association des juristes d'expression française de l'Alberta. It was a moment of pride for a small group of French-speaking lawyers, and now the Association for French-Speaking Legal Professionals has over 100 lawyers in the province.
Now the Court of King's Bench in November 1994, and afterwards as a deputy judge of the Superior Trial Courts of the Yukon and Northwest Territories, where I've worked as a trial judge in both official languages. As a member of a court of general jurisdiction for 23 years, before my appointment as its Chief Justice, I heard all types of cases, from trials to judicial review applications to appeals, with a large part of my trial judge years conducting criminal jury and judge-alone trials. I was also involved in those years with the Canadian Superior Courts Judges Association, which represents over 1,000 Superior Court appellate and trial judges across Canada. The association promotes the independence of the judiciary, fair judicial discipline processes, public education, and other important initiatives through a number of active committees. I was honored to be the association's president in 2011-12. Prior to my appointment as the Chief Justice, I was also a member of the National Advisory Committee on Judicial Ethics, a committee of judges from across the country that provides ethical advice to their judicial colleagues. In October 2017, I was appointed as Chief Justice of the Court of Queen's Bench, again at the time. It's a very busy trial court, with now close to 100 judges. I've led and been involved in several court projects focused on access to justice. In doing so, I've tried to follow the great Yogi Berra's sage advice. If you don't know where you're going, you will end up someplace else. So I made sure I knew where I was going, and with lots of help from my judicial colleagues and judicial staff in Alberta, we were proud to introduce one of the first respectful workplace policies to a trial court in Canada, and to adopt a comprehensive French language policy. We also created an Indigenous working group within the court that has introduced important Indigenous cultural traditions to our proceedings, including smudging and the use of the eagle feather for oath-taking by Indigenous witnesses. I can't thank my judicial colleagues in Alberta enough for their support, their hard work in our courtrooms, in our settlement conference rooms, and on our many court committees during my 6 years as their Chief Justice. I also want to recognize the support of Associate Chief Justice Ken Nielsen, who has contributed countless hours in supporting the court through those COVID years and in all its projects. And none of this would have been possible without the support of the dedicated lawyers and judicial staff of our court. I've also very much enjoyed working on improving Albertans' access to justice with both past and present Chief Justices of Alberta, the Honourable Catherine Fraser and the Honourable Ritu Kular, with both past and current Chief Justices of the Alberta Court of Justice and the members of Alberta's Ministry of Justice. I've been honoured to participate for several years in international education projects for judges, initially with the International Association of Judges and later through the Office of the Commissioner for Federal Judicial Affairs. Supported by a small, dedicated group in the international section of the Commissioner's Office, Canadian judges have provided advice and training to judges in several countries on a variety of topics, all of which are aimed at improving public confidence in their judicial system, which is the backbone of any democracy. As the former Chief Justice of British Columbia, the Honourable Robert Bowman, recently remarked, justice and the rule of law, like every truly lasting edifice, must be built patiently and carefully, one solid brick at a time. Our Canadian judges are well situated to make a significant contribution to emerging democracies, given Canada's bilingual and bijural justice system that reflects both common law and civil law traditions. My involvement in international work reinforced in me the importance of the rule of law and of an independent judiciary. I marvel at the resilience and strong commitment of our foreign judicial partners in improving their justice systems. Les principes universels d'indépendance, d'impartialité et d'égalité sont
The universal principles of independence, impartiality, and equality are the cornerstones of our justice system. I have been a member of the Committee on Conduct of the Canadian Judicial Council since 2020, and and truly there is a profound duty to ensure that that the way that legal professionals operate maintains the confidence of Canadians in the judiciary. I also had the honour of participating with the Honourable Jeff Moravitz, the Chief Justice of the Superior Court of Ontario, as a representative on the Canadian Judicial Council on the committee for acting to modernize the courts. The committee played a significant supporting role to Canadian courts during the pandemic and continues to provide advice on a variety of subjects that are challenging for courts under the co-chairmanship of the Chief Justice of Canada, the very Honourable Richard Wagner, and the Honourable David Limity. And now,
the importance of a diverse bench, diverse both in terms of our personal and professional backgrounds, to maintain public confidence in our justice system. The cultural background and lived experience of judges both challenge and enrich the decisional process at all court levels. Comme le juge en chef Wagner l'a bien exprimé en juin 2020.
As Chief Justice Wagner said very well in 2020, all Canadians must be able to see themselves in their justice system. Justice must not lead the person that has to face it to feel marginalized or excluded.
And such an incredible opportunity to contribute to the Canadian justice system at its highest level. Je vous remercie et je suis à l'écoute de vos questions.
Thank you. I am ready to hear your questions. Thank you. Thank you, Chief Justice.
Ask Senator Cotter, Chair of the Senate Legal and Constitutional Affairs Committee, to ask the first question. Senator Cotter.
Thank you, Mr. Moderator. Chief Justice, we know each other from the odd other movie. It's a special honor to be in your presence on this occasion. Congratulations on your nomination. I know time is short, so I'm going to pose two questions. I hope not too long. The first are they're bookends, I think. What motivated you to go to law school in the first place? Second question, you talk in your application about social context education. The new ethical principles for judges captures that in quite a rich way, listing ranges of knowledge and acquaintance. Could you speak a little bit about your interest in commitment to that and the way in which your court was moving to connect with social context education?
Very good. Thank you, Senator. Well, I actually went into law school after 2 years, and it wasn't even pre-law because I was torn between medicine and law. There's a large medical contingent in my family among my siblings, and I include, of course, my father. And I had a love of sciences. But at the end of the day, I thought that law would open more opportunities for me. And because I wasn't really at that young age too sure where my life was going to go, I did feel that it would be a really good undergrad degree. And as it turned out, I stuck with it. I became very interested and was very fortunate, actually, to have a young gentleman come through my office very early in my practice, and in his case, demanding a trial by judge and jury in French on a trafficking and cocaine charge. At the time, we didn't have in Alberta the criminal code provisions proclaimed that permitted the trial in French, and I said, well, I don't know what I can do for you, but I'll have a look. We'll adjourn for a couple of weeks and see what's out there. And out there was the Northwest Territories Act, which was, of course, a federal piece of legislation before Alberta became a province. Never quite revoked in Alberta. And so there started a career for me in constitutional language rights, which I'm not sure if it would have surfaced that early had it not been for that gentleman coming through my office. So that's, with respect to question one, I think I found my home in law. With respect to social context, it's a fundamental principle of the National Judicial Institute that lecturing of judges and learning for judges takes place in three areas: substantive law, procedural law, and always equally with that, social context. Judges are responsible for knowing the communities that they are exercising their profession in. And that means knowing about the vulnerabilities within that community. And I have been very proud to introduce diversity type of measures in our court. About a year ago, or maybe a little longer because time flies, we heard from a member of the 2S LGBTQ1+ community to discuss with our judges what their particular challenges are. And, of course, there have been a lot of projects that we've done on the French language side because that needed some work in our court. There are certainly the needs that come from the TRC with respect to every aspect of society, including our courts, taking an active role in reconciliation. And we don't do it by sitting back. We have to engage with the communities that are affected. And I'm very happy that our court has shown a lot of openness to it. And we're, of course, encouraged by the provisions, of course, that have made that more of a reality among our judges. That's 4, I guess. Thank you.
Thank you, Chief Justice. I wasn't aware that there would be a sound when the time would run out, so now we know. I'd now like to ask Lina Mettledge-Diab, Chair of the Standing Committee on Justice and Human Rights, to ask her question.
Merci beaucoup, Monsieur le Président.
Thank you very much, Chair. It is truly an honor for me to be here to ask you questions. And once again, I'd like to congratulate you. You talked a lot about official language rights.
Co-fondatrice de la...
So you were a co-founder of the Association of French-Speaking Legal Professionals of Alberta, and you also were involved in the Mahe case.
In that, as a former Minister of Acadian Affairs and Francophonie in Nova Scotia, and I know our French language minority school board, CACP, Conseil Scolaire Acadien Provincial, relied very heavily on those decisions back in the 90s. So that's one question. How do you see language rights have evolved in the last 30 years? And another question that I would ask is continuing judicial education, whether it be our judges here at home or you also have extensive international work with judges outside Canada. So I will let you speak on those because I don't want to dominate the. But it's phenomenal. Your background, your personal experience, your story is phenomenal, and we're very lucky to have you accept.
Thank you so much. Just in terms of language rights in the constitutional sphere, it's a developing area. So today I will not provide any theories as to where it's going or how it got here. But I think the fundamental premise of Section 23, which was discussed in my A, is that it has a reparatory effect. And in Alberta, of course, it was a situation where a population at the turn of the century, which was very strong in Alberta, had dwindled. And the determination, I think, of Parliament was that getting guarantees in place at the stage of a childhood education was very important in order to reverse the erosion of the language, and of course, with that, the culture. But so I was very, very proud and very happy that it's being read elsewhere, and maybe move on to the next question. It's been a real honor for me to participate in international education. It was something that I fell into. I think that my colleague, Le Sénateur Dalphond, is from the same association originally that sent delegates everywhere in the world to discuss things like how we deal with protecting complainants in a criminal proceeding. That is, in some countries, there are no protections. There's no support person. For example, there's no idea that one would separate the complainant and use video in order to lessen the stress of trial. So we were able to impart those kinds of ideas in other countries, and I realized that I really enjoyed doing it. So I was very fortunate to pursue it with the Office of the Commissioner for Official Languages. And we generally work in ethics, because in emerging democracies, the really important factor is building public confidence. And so without an independent judiciary in a struggling democracy, then you don't find that countries are investing in that particular situation. It's important on many levels for the population to understand that an independent judiciary is really, as I said, a backbone. There needs to be a trust in courts, and I'll just finish off there, but I could go on about international involvement. I hope I'm invited to do so. Thank you.
Donc la prochaine personne sur la liste.
The next person on the list is Senator Boisvenu, but he's not here today, so we will go to the next person on the list, and so it's Mr. Rob Moore. You have the floor.
Okay, thank you, Chair, and thank you, Chief Justice. Congratulations. Our Justice Committee recently completed a study on the federal government's obligation to victims of crime, and during that study, we heard from witnesses across the country about how they felt the justice system, having already been a victim, continue to re-victimize them. And through your extensive experience in criminal law and your experience as a Chief Justice, do you have suggestions from your experience that could help alleviate some of that feeling amongst victims of crime that, as was put by one individual who appeared before us, we don't have a justice system, we have a legal system. That was her feeling, her experience. So any suggestions for us as we look for ways to improve the experience of victims within the judicial system?
Difficult issue. I can probably only comment in a limited way. Because the Supreme Court is obviously called upon to adjudicate in this area. But it is not for nothing that there are provisions that require a judge at the time of sentencing to hear victim impact statements. The Bill of Rights of Victims, which is, I think, circa about 2015, it may be that it takes some time to develop a culture around those new provisions, but they are protective. They require transparency. And I say protective because it's obviously, as I said earlier in my remarks, it's a real ordeal for people to go through the criminal justice system. So being transparent about, as the Victim Bill of Rights says, disclosure to a complainant of the course of an investigation, disclosure of the result of a criminal trial, disclosure of perhaps when something is coming up for corrective action before the parole board, those sorts of things. Those are all, I think, very helpful. Within our courts, though, we do have the victim impact statement, which I think is very important. Judges must weigh that with all other sentencing factors. It can be done orally within the courtroom. It can be done by the prosecutor or read by the prosecutor on behalf of the victim. But certainly we as trial judges deal with those regularly. And so I hope that in individual instances, we perhaps are defeating some of the comments that you have made. It's obviously something that takes time. The standard of proof in a criminal trial is one that is it's high, beyond reasonable doubt, and it is in that context that we work. And so that does it does mean that there are cases that do not meet that standard, and there's a lack of comprehension why. And I think that's where judges come in, to articulate well the reasons why they are, in some cases, finding accused guilty, in others, as importantly, why they have acquitted. And myself, I've certainly always at the end of a trial, and there have been many, to evaluate whether I've made it clear enough to everybody there why I have determined a case in a way I have. And I think that's something that our education programs, or how to do an oral judgment effectively and how to reach out, I think is very important. So you demystify the system.
Alors, on va passer maintenant au sénateur Pierre.
Now the floor goes to Senator Pierre Dalphond. Thank you very much. Chief Justice Moreau, first, congratulations on your nomination for appointment to the Supreme Court of Canada. I know you. I have known you for about 20 years, and I know that your journey has been exceptional. You have experience. You are rigorous. You are not afraid of challenges, and you are not afraid to take responsibility. In other words, the process in place for nominations has provided an excellent result, and I am very pleased with that. So I have 2 questions, and you can choose which one you would like to go into more detail with. So these are 2 questions to enable Canadians to get to know you better. The first question is more of a personal nature. Could you tell us who in your life had the most influence on you and why? And the second question, which is a little bit more formal and professional, is this. So there's the relationship between Parliament and the courts as a dialogue. It's a constant dialogue between legislation and decisions. Can you explain that relationship a bit more? Thank you. First, you didn't ask about an influential lawyer or judge in my life, so I will take this opportunity to talk about my mother. And that's an interesting thing because my mother was Anglophone. She spoke English. She tried to take French lessons, and perhaps she wasn't completely into it. And I think that with 8 children, the effort was considerable. And as I was saying in my remarks, she did support my father's efforts to instill French in us, not only the French language, but the French culture in our family. My mother always encouraged me and said, if the door opens for you, you should go and see whether there's something interesting on the other side. So that means that a call from Radio-Canada at the time asking me to be a volunteer for Génie en Herbe, which was a show at the time. And, you know, I seized the opportunity because my mother always encouraged me to do that. My mother is still a voice in my soul. I think if that hadn't been the case, I would not have applied for this position, and she is very, very present in my heart. With regard to the dialogue between the government and the courts, that is a dialogue that has existed for a long time. And it's a way of interpreting the relationship between the branch of government that legislates and the one that carries out the law and then the courts that make judgments on the constitutionality of all of these things. So it's a way of looking at the relationship, and that's also developing. There are ways of interpreting how rigorous the Constitution is. I won't go any further, but I think that it should be recognized that this dialogue is still under discussion, if you will, and when the court indicates that part of a statute is unconstitutional, then it's up to Parliament to decide whether it will proceed to amend that statute. It is not up to the court to demand it. The court is there to answer, but if there is a request for an amendment, there can be a suspension of the ruling of unconstitutionality to give Parliament a chance to amend the legislation. Thank you. Now the floor goes to Réal Fortin. Thank you very much. Chief Justice Moreau, I am pleased to be here with you today, and I think that, like the others around the table, I looked into everything that I could put my hand on with regard to your past, and there was a lot to go through. And I know that we can count on you. I do appreciate hearing your answer to our colleague, Senator Dalphon's questions. I was going to ask the same question, so it saves a little bit of time, and I can address another question. So with regard to the protection of language minority rights in Canada, I think that you've been dealing with that issue throughout your career at a number of different times, and you will no doubt be called to continue to deal with these issues. So I will not ask you now what decisions you will make in the future. And if I don't answer those questions, I will not be offended. But in 2019, you talked about the judicial creativity that goes into making decisions. And I wonder whether that creative approach could be applied to the protection of language minority rights in Canada. And if so, what role could judicial creativity play? Answer. It's a very difficult question to answer because creativity comes from a factual situation that might inspire a solution that might be more original than another. And when it comes to language rights, it really does depend on the place, on the geographical place where it's playing out. Because as you know, the situation in Alberta is different from Manitoba. In the 1870 law in Manitoba, it guarantees official bilingualism. I do love the expression of judicial creativity because it has to do with seeing the person before the judge and to see also the repercussions, the broader repercussions for the community around that person. But I think I'll limit myself to that answer. So I'd also like to ask you a follow-up on the same topic. So when you think about linguistic minority rights, and I understand from your remarks that you were also a member of a minority language community, and I heard about your family's journey as such. But I'd like to hear what you have to say about what the rights of language minorities are. I know that the Supreme Court hears cases in that area regularly, so I won't comment in that direction, but I can talk about my own experience as a French Canadian, and that it's true that identity and it's very much mixed in with language and culture. And there are protections under the Charter in Section 23 that truly bring to life those protections of minority language rights. So what we learn with regard to minority language and minority culture rights can be applied more broadly throughout Canadian society. and that is linked to equal treatment for the various groups in society, and other minority groups can benefit from minority language rights. There was a case in the Northwest Territories where there are a number of official languages, and I asked myself, well, how can I simply deal with the rights of French Canadians there in that context without thinking of the other official languages? But I find that it's a good opening. And those who read my decision will hopefully continue to be motivated to protect their language and their culture. Thank you.
To Senator Dennis Patterson.
Congratulations for your nomination, Madam Chief Justice. You mentioned your work on access to justice. I'm a former legal aid lawyer, and we've noted a reduction in access to legal aid in many parts of Canada. So there have been more incidents of unrepresented accused and litigants before the courts. I wonder if you're concerned about this development and if you think anything can be done about this by the courts. And if I may, I note that in addition to your career, impressive career in the Court of King's Bench in Alberta, you were deputy judge in NWT and Yukon with significant rural populations. And I noted in your questionnaire, you emphasized the need to respect the differences between urban centers and rural areas, and that it's critical this be considered by the institutions of justice. Could you elaborate a bit on what you meant about those differences in culture and attitudes between urban and rural?
Maybe I'll start with the second because I'm not sure how much I can say about the first.
Okay.
And when you're Chief Justice of a province like Alberta, we have 13 judicial centres throughout the province. The two big ones are Edmonton and Calgary. Huge urban centres, lots to deal with. But you also have other pockets, other communities within the province that, for example, some might have a higher crime rate than others, regional difficulties that we don't see as often in our cities. And so you cannot have a one-size-fits-all solution to justice in a province with that kind of, those kinds of differences. So that's why I'm very keen on our judges, despite the ascendance of video, to be in the regions and learn about the individual problems in the regions. And so I guess that's what I was getting at, was being intuitive to the needs of one's community as a judge. And it cannot be an urban, sort of a closed view of an urban community or a rural community. On number one, obviously we know that the self-represented litigant has become more prevalent in our courts. I would say particularly in my province, in the family law area. And certainly there's a lot of discussion about funding legal aid, but that's unfortunately not my dossier. That's for government. What we try to do to palliate against that is there's something called the Robotham application, which in particular cases where the charge in a criminal case is complex, and there is little doubt that the accused cannot defend themselves properly. And of course, if there are, the means test is also there, the court can make what we call a Robotham order, which is an appointment of counsel, likely on legal aid rates, but it is certainly a remedy that is available in those serious instances. The court also has the ability to appoint an amicus curiae. So if the individual, again, you're in a jury trial, and it's very difficult for a self-representative individual to navigate through a trial, but might not have otherwise been eligible for a Robotham lawyer, then the court has the assistance of an amicus curiae who can present arguments on behalf of the accused in the sense that here are the counterweighing arguments, the Crown. They actually don't act for accused people. Those are some of the things that have happened in the years more recently to address what I think will be a problem for the legislators and the executive side of government. Thank you.
Lisa Marie Barron.
Thank you. Congratulations to you, Chief Justice, and I'm just honored to be here to be able to ask you questions today. I'm going to ask you two questions, and you can decide what order you want to answer them in. The first question that I have is that we're all seeing the impacts, the terrible impacts of the lack of access to mental health supports on Canadians. And I'm wondering what you see as the role of the Supreme Court and yourself as Justice playing in changing the attitudes towards mental health issues in our legal system. And the other question that I have is, as you know, reductions in access to legal aid has resulted in an increase in the number of unrepresented accused and litigants before the courts. And I'm wondering if you can share your suggestions as to how we can ensure all Canadians have access to legal aid, and provide your thoughts around the impacts when they do not.
Obviously, I dealt in criminal law with the very, very sad situations of mental health issues in an accused person. And I can't really say much about that in the sense of where the legislator has to fit in. You know, there's been discussions in the past about how one deals with FASD accused, and we know that they struggle individually in the system. And yet, the criminal code does provide for there are penalties for criminal acts. We hope that the mitigating factors that we deal with, and that's our province of judges, will allow for perhaps what I can do is say the creative type of situation within the bounds of precedent. And I think certainly the Supreme Court of Canada deals with sentence appeals. They look at the situations. They may, I think it'll be an honor for me to be able to evaluate from that perspective what a judge might be able to do in a particular situation to address these mental health factors. But I think that's about all I can say about them. Your second question, I think, really hit what I was speaking about before. So I'm not sure that I have much to add to that particular question.
Well, then I'll use more of my time. Excellent.
Yes.
Thank you so much. It's very exciting to be able to be here knowing that with your nomination, we will see a majority, that women will hold a majority on the bench. And I'm wondering if you can speak a little bit more about what that means for gender equity and any thoughts that you can provide to other young girls and women who aspire to follow a career path similar to yours.
Well, I'll tell you about mine, because when I got into law school, we were quarter women back then. And then I decided I really liked criminal law and looked around me, and there were very few women practicing criminal law at the time. A few years later, I became a judge. Quarter of the numbers in our province were women only. That was the number. We have seen an incredible improvement. The law schools, we know, at least 50% in many cases are women. Appearing in court, in my court now, are many very talented, skilled women criminal lawyers. And our court is now very close to 50%. I think I've had something to do with that, I hope, over the last 6 years. And now, of course, for me, it's a real thrill to think that, with depending on what happens next, I may be part of a court that is actually majority women. So, I think that what will be a really neat thing, if I might say, is when it's not remarkable that a majority of a court is women. Thank you.
Merci. La sénatrice Denise.
Thank you. Senator Denise Batters.
Moreau, in your Canada questionnaire that you prepared, you highlight your 2019 Omar Khadr judgment in your skills assessment section. You stated, quote, "I chose this judgment to illustrate how I took a creative approach that was nonetheless grounded in the principles governing sentencing," unquote. Omar Khadr, of course, had been convicted of murdering a U.S. medic, and in your 2019 judgment, you ordered that Omar Khadr's remaining conditional supervision period of 3.5 years be reduced to 1 day. Justice Moreau, media reports about your considerable legal and judicial career at the trial level reference your experience in criminal law jurisprudence and state that you had presided over many murder cases. And yet, with all of this for background, in the entirety of the Supreme Court questionnaire that you prepared and the part that we were provided, including in the section, Who is the Audience for Supreme Court of Canada Decisions, I was a little bit surprised that you didn't include any reference to victims of crime. Why not? And how do you view victims in that context as part of the audience for Supreme Court decisions?
Well, I would think that somewhere in that questionnaire we would be speaking of victims, but I'll take your comment because it was 29 pages, and I won't check. The work that I've done through our court dealing with comforting victims within the courtrooms, I think speaks for itself, that record. When I speak of a creative sentence, I cannot comment on my decision in Cotter. I wanted to give an example of a decision that was made when I was the Chief Justice because we were very, very preoccupied with COVID during that time. And I was not as active in the courtroom. For example, could not afford to get involved in a 3-week murder case as a Chief Justice. So it was an example of a recent case. Creative in only in the sense that the sentence that the 3.5 years that was then converted to a 1-day sentence was because there was as I noted in the questionnaire, 3.5 years on very strict bail conditions that in essence replicated the terms of a conditional sentence. So to that extent, I think I can't comment any further, though.
Thank you. Justice Moreau, all of my ancestors were Ukrainian. And of course, that's a very common circumstance in your home city of Edmonton, or Edmundchuk, as some joke. And I noted in your Supreme Court questionnaire that over the last several years, you've had considerable involvement in training judges in Ukraine. As one of 1.4 million Ukrainian Canadians, I thank you for that important work. And I would like you to tell us a bit more about that work with Ukraine.
Right. Well, certainly it was about a 4-year project, and obviously we're not there now. And it's great with great disappointment that we are not there. But we focused on shoring up confidence in the judiciary, again, in much the same way I described in other countries, and that is that a sound set of ethical principles is something of great assistance to judges. In some countries, they form part of a law. I've been working in Mongolia, and it's in fact in the law of Mongolia, the whole set of ethical principles and guidelines. Whereas in Canada, it's a set of principles. It's what is people want to achieve as opposed to a minimum standard, what people want judges to achieve. But there were 2 main issues that I was involved in, and the first was communicating to the public so that you can actually create a pathway, a lot of times through the media, and we met with media personnel. We wanted to try to demystify and render transparent court proceedings there. That is a bit of an issue in many of these countries. They don't have any gallery space, not for reporters, not for members of the public or families. And so, you indicate the importance of that. We had them over here a couple of times in Canada to look at our courtrooms, watch court proceedings. So communications is really important, but also obviously the issue from a public perspective is one of trusting their judiciary. And so the only way you can do that is to have a sound system in place, a framework that the judges work within. You can't just do it one case at a time. You need to build that framework, and we helped them do that when I was there. Yeah.
Anthony Housefather.
Merci, Madame la Justice en Chef.
Thank you, Chief Justice, and congratulations on your nomination and for your hard work for language minority communities. I'm sure that your experience as a Franco-Albertan will be of great use to the Supreme Court.
But a different linguistic minority that I'm part of, the English-speaking minority of Quebec. And don't worry, I'm going to mention some laws, but I'm not going to ask you to comment on the laws. My community is going through what seems to be a bit of a crisis right now in terms of feeling alienated. We've seen Quebec adopt Bill 21 using the notwithstanding clause preemptively, Bill 96 using the notwithstanding clause preemptively, and in my view violating Section 133 of the Constitution Act. Bill 40 that eliminated English language school boards that has been, that has been enjoined by the Superior Court and 3 judges of the Court of Appeals, and in Judge Lucier's judgment of the Superior Court, struck down in violation of Section 23 of the Charter of Rights. I guess my question to you, you're going to be faced with a lot of cases that relate to both linguistic minorities. What is it that you know about the English-speaking community of Quebec? Do you feel that you know us well? And if not, what will you do to educate yourself about our community?
Well, interestingly, when I was a lawyer, the Alliance Quebec was an intervener in a language case in our Court of Appeal, and I acted for them. So I think there was certainly some familiarity at that time as a lawyer with the realities. But I think as a judge, I really can't talk about the comments that you've made. I really can't discuss them. I don't know what further I could add than to say that it is why we have a Supreme Court of 9 people. We have regional representation. I'm from the West. I know my area of the world fairly well, and we count on our 3 justices of the Court of the Supreme Court from Quebec to know theirs as well. And so I think that's what makes a very interesting court and allows us each to make a contribution from our perspectives, both from our personal backgrounds, as I said in my comments, and also professional.
So another question is, obviously I've been very concerned, as I think many Canadians have, about provinces preemptively using the notwithstanding clause. I mentioned 2 cases before. Saskatchewan has recently used it. What would be the criteria that you would point me to for when you would overrule a Supreme Court precedent? I think that's a question that I've asked previous nominees, and I have gotten you can refer me to another case that you can tell me you don't want to answer it, it's fine.
I won't answer it.
Yeah. My view is that question is a matter that may very well come before the court, and so it's not an appropriate question.
I can't hear a word you're saying.
I'm sorry. My view is that question is may very well come before the court, and so it's not an appropriate question.
What are the criteria that you? Well, all right. Well, then let me come back to another question. And in 59 seconds, I've asked this one before also. Why do you think you'd make a good justice of the Supreme Court?
Well, I think 23 years of what we like to say in Alberta, being in the trenches. We're a court that deals with trials continually. We are a very busy court, and so I actually think that. When you're in the middle of a murder trial and there's an issue of admissibility and you've got to deal with it because there's a jury of 12, or now we can have juries of 14 waiting in the back room, you learn to get on top of issues and make the decisions that you need to keep the wheels of justice going. So I actually think that experience of mine has been very helpful to me. As a Chief Justice for the last 6 years, you got to learn to work collaboratively with government and with our judges. And so that's part of the answer. Thank you.
My apologies for the bell. I've been trying to get in there before it rings, but I was paying too close attention this time. Senator Andrew Cardozo.
Madam Justice Moreau, congratulations on this important nomination. I do want to just do a shout out to the law students who are here in the room. I think it's a wonderful to have them here to be part of this very historic day for all of us. My question, Madam Justice, is about what I believe is the growing polarization in our society, and indeed much of the world. This polarization plays out certainly in the area of human rights. I look at trans rights for one example. Over the last decades, the demands for and the understanding of trans rights has grown considerably, but at the same time, the opposition to trans rights has grown to be loud, vociferous, and even violent. As the courts seek to make their decisions with evolving attitudes and norms in society, how should the courts deal with the growing and more polarized attitudes in society?
Well, it's the whole reason for the Canadian Charter of Rights. It's a map of human rights that are fundamental. And when courts in individual cases are called upon to enforce human rights, the Charter is there for that purpose. I think that that's all I can really say is that it's a very strong document. It intervenes in many real-world situations when there are state agents involved in unfair treatment of individuals, if that is to occur. That is a lot of certainly what I've seen in terms of the use of the Charter in the different courts is to determine whether or not the state agents have gone beyond the appropriate realm. And the Supreme Court of Canada has been very helpful in setting up what the frontier is for dealing with breaches of human rights. So that's our field. I can only speak of the courtroom. I don't think I can go beyond that. Yeah.
Another quick question, although may have a long answer. Can you share any experiences through your life which have shaped your values and views about minority rights? And I speak especially of Indigenous people and racialized minorities.
I think the frustration that my father felt about not being able to increase the level of French education for his children, which got, I think, him involved in some proactive work in that area. It was a frustration that it passed on to us. So, when you're in grade 3 or 4, you don't notice it. When you're in grade 10 or 11, and you want to be, for example, going as I did to Campus Saint-Jean, which is a French faculty, and yet, you're not quite as well equipped as others might be in other provinces to do it. I felt that frustration. And so I knew that in Alberta you have to work hard to maintain the language and the culture. I think what you said about the trans community means there's been improvements, and in many areas there have. But I do think my own experience, I guess, must have motivated me in some way to take this on. It certainly was of interest to me, the whole issue of language rights. But there are a lot of, there's an important dynamic behind that, and it's all about minority rights. So I think there's a lot to be gained from language rights litigation, if you look at it that way.
Yeah, thank you, and I wish you the best.
Monsieur Frank Caputo.
Thank you very much, Chief Justice. It's a pleasure to be here. I'm not usually so happy to be surrounded by so many lawyers, but it is wonderful to be here.
Students.
And students. Students are great. I really miss teaching. Used to teach at Thompson Rivers University. Shout out to them before I was elected. And also appreciate as well when you talk about access to justice. My wife is a clinical lawyer. She's worked in legal clinics for many years and is doing research on access to justice. So I want to ask you a question. I'm sorry if this is overly philosophical, but it's one that I've grappled with for many years, and that is the dialogue, and this was touched on by one of the senators, the dialogue between the Supreme Court of Canada, well, the courts generally, but in particular the Supreme Court of Canada and Parliament. I believe it was Justice Iacobucci who called it that dialogue, because on the one hand, you have Parliament, in this case 338 elected members, who are passing laws that ostensibly reflect the will of the people. And then we have 9 judges in the case of the Supreme Court of Canada who are appointed by the government of the day, expected to interpret those laws. And sometimes there can be a tension. Oftentimes there's a tension, if we're being candid. How do you see that playing out, and what are your views on that?
Well, I think that at the beginning you have to accept the premise that it is the legislature who set up the dynamic of the courts reviewing laws for compliance with the Charter, for example. And so it isn't the 9 judges who are dictating that process. It was, in fact, elected officials who made the determination that there is a twofold role for the court, the Supreme Court, a more robust role perhaps than a trial judge has, which is to obviously interpret the law, but also measure laws against constitutional documents to determine whether or not they pass constitutional muster. So I see it in a different way, with all due respect.
Well, that's interesting, and I didn't expect us going down this path, but let's go down it, perhaps. I see we have a minute and 45 seconds. Because, I mean, the Charter came into force in 1982, and with the passing of the Constitution Act of 1982, the law was, the judiciary had great powers that really did change how parliamentary sovereignty operated. I think we can all agree on that. And we talk about here, you're talking about, well, at the end of the day, Parliament gave us those powers. But I still think there's a discussion to be had, because in the since 1982, I was 4 years old, so 40 years, 41 years, there's been considerable change in the law. So I think that this is a discussion to be had, because at the end of the day, there is a lot of back and forth, and that jurisprudence has evolved quite a bit. Do you get where I'm saying? Do you get where I'm going on this?
Well, certainly the law evolves. There are a number of doctrines that are at play. We can talk about living tree, for example, is one doctrine that's interpreting constitutional documents. We can talk about something called originalism. There is purposive textual interpretation. These are all considerations really that are in the mix right now. And I think I can't say much more than that, because I'm going to be called upon as a member of the court to work my way through that with my colleagues in particular fact situations. So I think I'm going to just leave that, park it there. Thank you.
I'm saddened you can't comment more, although I understand your rationale. Thank you.
Sénatrice Bernadette Clément.
Senator Bernadette Clément. Congratulations, Chief Justice Moreau. I'm so pleased to be able to meet you today.
Of Black and Indigenous peoples is a key area of concern in our criminal justice system, and we know that it is a systemic problem. In your questionnaire, you stated that judges have a responsibility to hone their legal and social context knowledge to ensure respect, fairness, dignity, and to clearly and definitively eliminate myths and stereotypes. So I have some questions based on that. Vous êtes une fière Franco-Albertaine.
You are a proud Franco-Albertan. You have lived in a minority context. You have had a career where at times you were the only or the first one to go into a particular space. And I was wondering how that influences the way you understand diversity.
Two, what might be the limitations of your perspective in terms of diversity, and how do you strive to overcome them?
Let me start with the second one, because I think that's it's an advantage to be 9 on the Supreme Court of Canada, because those areas that are lacking in my experience, we may find in others. And I think my colleague, if I am appointed to the court, Michelle O'Bonsawin, Justice O'Bonsawin, demonstrates that. I'm not Indigenous, and I have a lot to learn. And I think that being a minority actually makes me remember that I've got a lot to learn. So that's why I think education programs for judges are so important. The idea that judges in my province, as directed by the Canadian Judicial Council and all other provinces and territories in Canada, must take 10 days of judicial education a year. We don't sit, we go to school. We learn about social context issues. We talk about myths and stereotypes and how they can creep into our decision making, and it must not happen. So I think it's an important topic, and perhaps just having lived through some of the experiences of a minority, I'm especially alert to it.
I guess I want to ask about how you personally overcome that, or how you personally work towards that. I understand there's colleagues, I understand there's judicial training, maybe from a more personal perspective.
Well, I was challenged. I was young at the job. When I got the call from Ottawa, I was 38 years old. I believe it was because the criminal code provisions in Alberta that allowed for judge and jury trials and judge alone trials in French required us to have a bench that was composed of some French judges. So I think I got the call a little earlier than certainly one would see these days. And there were some remarks that I heard about lack of life experience, way too young for the job. And my response to that was what my mother said often, and that is the proof is in the pudding. So what I can tell you is that I worked hard in those early years to be on top of things, and I actually have never abandoned that. And that's certainly my intention as I enter, if approved, enter this next chapter of my life. Thank you.
Mr. Marco Mendicino.
Merci. Je vais vous féliciter pour ta nomination.
Thank you. I would like to congratulate you for your nomination for appointment to the Supreme Court. I am convinced that you would be an excellent addition, and I am sure that everyone at home is very proud of you.
That you are one of 8 children, 6 of 8. Your parents almost had a Supreme Court of their own in the house, which will no doubt make you a very collegial and positive team member. You're familiar with the numbers and the dynamics, so
Yes.
Congratulations, Judge. I have 2 questions. One related to your trial experience. I'm a former prosecutor. I've spent many an hour in the courts, and one of the things that is replete within appellate jurisprudence is the advantage that trial judges have in observing witnesses for their credibility. But it's more than that, I would submit. It's the ability of the parties to the court to get to know the judge and to get to know the process. And I wonder if you could talk about that skill set that you bring, which we understand is an institutional need to the Supreme Court. And then I have another question.
Well, certainly judges at the trial level are called upon to make findings of fact. And also, those findings of fact can't be simply based on demeanor, because people have their own, they can be shy, they may not want to make eye contact because they're in an environment that's very intimidating. And so the role of the judge in those circumstances, I think, is to try to accommodate people in very stressful situations. And so we do so, but we got to do so fairly, because the process has to not only be fair, but appear to be fair to everyone in the courtroom. But I think I mentioned earlier, one of the great advantages, I think, of being a trial judge, in working in trial courts is you have the chance to really articulate, as I said, why it is that you are making a particular decision. I don't see that as the negative part of the job. I see it as absolutely what is the most positively challenging. And I think that skill set has to be developed early. And we, even in the context of our oral judgments, in half-day applications, in applications for interim spousal support, these are 2 people who are before you who need to know why it is you're making a decision that you've heard them for 20 minutes. And I think it is important to stop, articulate, if that means, taking a half hour to consider your decision so that you can, and certainly in the early years you do, take a little longer. But I think that is the most important. And I think that can stretch right out to the appellate levels as well.
And I'm just going to ask you to expand on your approach to legal writing as a device to make the courts accessible. Coherence, clarity, understandable language, where appropriate, informing that language with historical and cultural sensitivity. Can you speak in the next 40 seconds about how we can count on you and others to use language as a means of shoring up public confidence for the courts?
You've said it so well. Quite frankly, I'm not sure that I could say it any better. It's important to articulate in a way that the public understands. And actually, that's the work that's done internationally. It's one of the pressing points is to make judgments understandable to the public, and that creates sort of a transparency between the courts and the public, and again, increases confidence. So I couldn't agree with you more.
Thanks very much.
Thank
We're very
you.
proud.
La sénatrice Renée Dupuis.
Senator René Dupuis. Thank you very much. Justice Moreau, congratulations. You just answered that you worked hard. And I have to say that I have no doubt that you worked very hard indeed. And congratulations on your nomination. My question is this. So you have a great deal of experience with the law as a lawyer, as a judge, and I was wondering whether you could tell us briefly about one or many principles in our judicial system that have evolved a great deal over the course of your career. I began my career when the Charter was born. It was necessary to move forward in cases where I was a defense lawyer to decide whether it was worth it to make a claim to set aside evidence in a given case, given the behavior of a police officer during the arrest of the accused, for example. So these were cases, and this was a time when courts and lawyers were adjusting to the new reality. And it created quite a few challenges. I think that the state of the law has solidified around sections of the Charter, and now a lawyer can more clearly see, based on the jurisprudence in the province, whether there is a chance or not to be able to use Charter arguments. So when you look at what the Supreme Court has ruled with regard to upholding the Charter, I think that you can see that the state of the law is quite remarkable thanks to that. Thank you. Question. I'd like to come back to the dialogue that my colleagues mentioned between Parliament and the judiciary, including the Supreme Court, and also the point of view of the federal parliament, which is the House of Commons, and the Senate.
Ending virtually.
Hello, bonjour, Madame Moreau. Ça fut plaisir de vous rencontrer.
Hello, Ms. Moreau. I am pleased to be able to meet you virtually today. Congratulations.
When you were appointed in Alberta to the Court of Queen's Bench and now King's Bench, you made sweeping changes when it came to the digitization of the courts. And I was wondering if you could possibly speak a little bit about that and what you would like to possibly change, if anything, on the Supreme Court.
Well, I think I'll have to get to know where they're at with digitization, and I suspect that they would be well advanced. I'm in a larger court among two other courts in our province, and so the resources had to be apportioned such that it perhaps hasn't gone as quickly as I'd like it to have happened. But we are in the age of digital progress, and as you know, COVID is really what lit the fire under it in our province, because we were forced to resort to email filing of documents, which meant that the paper still didn't disappear. The lawyers emailed documents into the clerk's office, and then the clerk's office had the laborious effort to photocopy everything so that they could create that paper file. So that has been a great frustration all around, and we are moving quite rapidly now into the digitalization. For example, our applications for probate now all done digitally. A lot of the commercial work of the court is done digitally. And what I, as a judge, appreciate, I think, is that when you see boxes of paper coming in, it's rather intimidating. When it's digitalized, you can take the document one at a time, and I think it's much more efficient. It's certainly more environmentally friendly, and it's with us. But having said that, there still is a role for the personal attendance of people who are involved in a parenting dispute, who are involved in a criminal matter, to be present in a physical courtroom. It really does bring home, in cases of significance, the weight of the law and the importance of the oath, for example, if testifying. And so I don't want to get rid of all the trappings. But for matters that are more procedural than substantive, I would say that the video opportunities are excellent. And I would also add that in the appellate practice, where you don't have the situation of witnesses giving evidence right before the court, the findings of fact have been made in the court below, that it could be another approach, obviously, that might be very convenient particularly in the Supreme Court, which is a national court in a very large country.
Thank you. You made comments about the understanding the difference between urban and rural earlier on in your testimonies. If you are successful in this, you will be required by law to move to the Ottawa region. How will you stay in touch with Alberta and particularly rural when you are forced by law to be centrally located?
Forced is a kind of a big way of describing it. I'll talk to Senator Simons about it. I don't think she felt too forced about it, but my fellow Edmontonian. Well, no, my roots are in Alberta, and I have 4 children in Alberta, not in the same place. And so I will be back often, and I continue to be very interested in Alberta and Western news because I'm a Westerner. So you continue to read about what is happening, and we have so much access to information through that means. But it will be an adjustment for me. I'm kind of excited about it. I have been a lifetime resident of Edmonton, and so just seeing what's available in Ottawa, the Riopelle exhibit for one, that I want to get to, things that maybe aren't as easily available in my end of the country. So thank you.
Thank you. Senator Kim Pate.
Thank you very much, and welcome, Chief Justice. It's an honor and a privilege to be here with you. I want to go back to something one of my colleagues raised. In your application, you talked about Omar Khadr's case and your ability to take a creative approach. You also mentioned elsewhere in your nomination package the importance of Section 718(2)E of the Criminal Code, particularly when it comes to sentencing Indigenous peoples. And despite that, we know that the mass incarceration of Indigenous people is increasing. In fact, this morning, the Office of the Correctional Investigator released more quite damning reports about this issue, underscoring the concerns. The barriers to fair and just sentences include things like mandatory minimum sentences, evidentiary records in guilty pleas, or even trials that fail to examine or adequately assess or contextualize social history factors. And we know that when it comes particularly to women, their ability to actually have those factors represented as factors as opposed to risks is a huge challenge. Via legislation and policy, including adoption of the TRC calls to action, the Missing and Murdered Indigenous Women and Girls calls for justice, the UN Declaration on the Rights of Indigenous People, Canada has committed to end, not just reduce, but end overrepresentation of Indigenous peoples in prison by 2025. I'm curious as to whether you feel comfortable expanding on the role that the court may have, particularly the Supreme Court of Canada, and the potential for signaling and encouraging creative options, yet principled approaches in sentencing in terms of responding to this incarceration of the the mass incarceration that my colleague also spoke about in terms of those of African descent and other racialized, but in particular of Indigenous people, and most especially Indigenous women who now represent 1 in 2 of our federal prison population.
Well, thank you. I mean, this is a very important issue, and particularly actually in my province where we have certainly an overrepresentation of Indigenous males and females in our detention centers, in our prisons. I think the one thing that has developed well in our law are the Gladue principles. And the Gladue principles require judges dealing with Indigenous accused persons to dig deeper and find out about the individual characteristics that have maybe contributed to the crime due to the intergenerational trauma that we know has been suffered by grandparents, parents, and I have heard the stories. And so I think the learning that comes from a Gladue report for individual judges is very important. It influences our thinking and it educates us in dealing with the next case dealing with that kind of trauma. And we do, I think, try to be responsive to individual factors within the framework of the law, because you've mentioned minimum sentences. And you've mentioned, and in my province, there are guideline sentencing principles that judges are encouraged to fall within. And so it's obviously, I talked about one brick at a time in my earlier dissertation, and I think we still have to build a lot of bricks here. But we have the makings, I think, particularly with the Gladue factors, doing something in individual cases that I hope will help with that rate of overrepresentation.
Madame Elisabeth Brière.
Elisabeth Brière, you have the floor. Thank you. Justice, congratulations. I was very proud to hear that you went to the University of Sherbrooke. That's my alma mater in my riding. The Code of Civil Procedure of Quebec is really gives an important place to private means of prevention, such as mediation, arbitration as well. How do you see using alternative methods like that, facilitating access to justice? And in the Code of Procedure, there's also the rule of proportionality, which means that it is important to take into account the cost and the time required given the nature of the case, the complexity of the case as well. So how could that rule also facilitate access to justice, and what role does it play in that matter? Thank you for that question, because as a Chief Justice, it is of great concern to me. I want to find ways of making justice more accessible at a lower cost to parties that are in the midst of a divorce, for example. In my court, we set up procedures, and I'm not talking about the Civil Code now, because my field is common law. But a great deal of energy has been put into projects in Alberta to promote settlements before the parties get into an adversarial situation. So we try to encourage a settlement that will not harm the children who are often caught in the middle, particularly when it comes to the issue of custody. So that's one example. My court also provides a last way out after a trial that would go on for weeks and weeks, and say, would you like to go to another kind of settlement rather than going to court? So really, there are various ways of trying to prevent the adversarial approach. And here I'm mostly talking about family law, because really the approach of going through a long, drawn-out, expensive trial process is not desirable for families. I know that at the Alberta Court of Appeal, they also have these ways of settling, even when there is a good chance of actually being successful on appeal, because they know that, in fact, the whole process of appealing is very heavy. So I think that really, at the Supreme Court, that's where the decisions are made when leave of appeal is granted. I have just a few seconds left. And there was the issue of digitization of documents. What about the modernizing of the legal system in general? Answer: yes. I think that digitization helps with modernization. And I know that there are a number of people in the court system that have to get used to digitization and ways of doing things more efficiently and effectively. I do think that it's a good idea, or it's good to say that, in fact, digitization will bring in other types of modernization.
Thank you. So very honored to meet you, Chief Justice, and congratulations. I have a question about reconciliation between Indigenous and non-Indigenous peoples. And Indigenous peoples are intimately connected to their traditional lands and resources, and they view their rights as inherent rights that exist even before the founding of this country, which in part includes the inherent right to self-government, which in part flows from the fact that independent Indigenous nations existed as independent nations governed by their own customs, laws, values, and traditions. And certainly there have been many studies and reports that have been that outline the relationship and the history that Indigenous peoples have faced. The Royal Commission report on Aboriginal peoples. We have the Truth and Reconciliation report as well, the Missing and Murdered Indigenous Women and Girls report as well. You know, we do have the Constitution and Section 35, which recognizes and affirms Aboriginal and treaty rights, and also international and domestic laws, United Nations Declaration of the Rights of Indigenous People, and the Federal Act to implement that. So with that in mind, I'm curious about what role do you see judges and courts playing in advancing reconciliation between Indigenous and non-Indigenous people in Canada?
I think I'll just speak of my own experience as a Chief Justice. I think it's very important that the institution provide opportunities for reconciliation. And in doing so, I think, you build the trust that, history has shown. I think it's something necessary for us to do. How we do that is, I think, perhaps just the little steps. The idea of going up to Big Stone Cree Nation in the north of the province to celebrate a feast as a member of the court, speak to the chiefs, participate in a smudge, make the smudge available to those who are in our system, who can't get access readily to, if they're detained persons often, can't have access before they testify to the purifying element of a smudge, facilitating the eagle feather in every one of our jurisdictions, and that includes our provincial courts as well. sitting in, I think, 72 jurisdictions in this province, in addition to the 13. Each has in their special box an eagle feather to allow Indigenous witnesses to feel the comfort of it and that tradition in testifying. So those are little steps. We have an Indigenous working group now. Very proud to have that group advise, or it did advise me before I got here, on Indigenous initiatives that we can take. For example, signage, now digital in our court, or will be in English, French, and Cree in the northern parts of the province. So the idea of having Indigenous courts, and I was recently at the opening of the Tsuut'ina Nation Indigenous Court outside of Calgary, and it's a wonderful environment. It's round. This isn't quite round. It is. Room for elders to assist, for example, in the sentencing process. So I think the courts, judges, have that role to play within our environment. I can't speak of interpreting Indigenous rights, rather. I think more than to say that, because obviously we know that there are many cases before the Supreme Court of Canada that will address and deal with those particular issues. So that's about all I can say. Thank you.
Mr. Taco von Popta.
Thank you very much, and congratulations, Madam Justice Moreau, on your appointment. Looking forward to the work that you're going to be doing in our Supreme Court of Canada. It was stated earlier in this discussion today that this Justice Committee earlier this year undertook a study on victims of crime, and particularly Parliament's responsibility towards them. And we heard many heartbreaking stories, particularly from victims of sexual assault, who felt that the court system didn't bring them justice. They said that when they were on trial, when they were in court giving evidence, they felt like they were on trial, and they were being re-traumatized. Now, of course, we all recognize that accused people have legal rights. Right to a legal defense, right to be presumed innocent, right to cross-examine witnesses, right to meet the accused in court. But it doesn't feel like justice, particularly to sexual assault victims. And the result of that is that very few sexual assault cases actually go to trial. So my question to you, it's just a broad philosophical question. Is there a better way to do this?
Well, I think I'm working within the system that has the trials. I don't work in your area, the area of the legislator, who might be looking at creative options. But I think as a judge, I receive the case and I have to deal with it as best I can. It doesn't, however, mean that judges shouldn't educate themselves on the kind of traumas that you are describing, particularly noting also to be very careful not to incorporate myths and stereotypical thinking in their treatment of witnesses. And I think that beyond that, creative solutions may well be something within the province of the legislator.
Thank you. Recently, Parliament passed a law requiring judges to undergo sexual assault case education. And what are your views on that? Like, are good courses being offered, and are all judges undertaking that course of education?
It's something that the National Judicial Institute has very much wrapped its mind around. And certainly it's been expanded, as you know, legislatively, not just sexual assault, but domestic violence as well. And yes, our judges are actively involved in coursework in that area. The one thing that's interesting about teaching judges about social context issues is that we feel strongly as a judiciary that it should be from judge to judge. because of the independence of the judiciary as a branch of government. And so that is how the education is delivered. I think you'll see in my questionnaire I was involved in doing so. And it's a very heartening experience to have colleagues from all over the country willing to spend time, because it's volunteerism beyond what we do, to teach each other. And we have some really fine teachers in that regard. So I certainly think that we've taken this to heart. Certainly believe in it strongly for my own court.
Thank you.
La sénatrice Paula Simons.
Senator Paula Simons. Thank you. Congratulations and welcome to Ottawa.
Have to live here. And in fact, shortly I'm going to head to the airport to fly home. But I promise to take you to all the best places. So when you became Chief Justice in Edmonton, you made it a vow, a passion of yours, to make the court more open and transparent and to work more collaboratively with the Edmonton media and with the Alberta media. And I wonder if you could tell all my parliamentary colleagues why that was so important to you, how you went about doing it, what you learned from it, and what you think you might be able to take to the Supreme Court from that experience.
Yeah, I mean, the media, the eyes and ears of the public. So that's where you have to start if you want to build public confidence in your justice system. And I was perhaps influenced by my summers. As a reporter, I have to emphasize summer relief as a reporter, but also as a Puini judge, which is when you're not a chief justice, you're a regular judge, heading up the media relations committee of our court. So one of the things we did was to meet regularly with, in those days, the print media. And we would meet separately with televised media. And so we'd find out things like we are freezing in your minus 30 weather when you make us stand outside the courthouse, and we can't put our equipment anywhere, and it doesn't work at times. So you build a cupboard. And then that solves that problem. It seems like a small problem, but for a reporter working daily in the courts, it is a challenge. And the idea of creating summaries of our decisions, because some of our decisions are very lengthy. So if the judge has some hand in preparing a very plain language summary of their own decision, then it's awful handy for a reporter to be able to have that as opposed to trying to interpret the 30-page decision. And I know the Supreme Court of Canada is actively involved in that, and it's good news, I think, for Canadians. So, I'll start there. There were a number of initiatives that we have taken. The one other big leap for me was a communications officer, and that was the first in Alberta. And I was aware that a former journalist who worked only in the courts was thinking about retiring. And I remember interviewing him and saying, I actually don't really know what your role is going to be. I know that I need you. And we sort of built it together. And it's been, I think, very good for the court. And it builds a bit of trust between the media and the courts. Maybe more attention to checking the facts when reporting, because there's somebody you can talk to do that fact check. So it's been a really very fruitful part of being a chief.
Thank you very much. I know there are others wanting to speak, so I will end it there.
Yeah.
Mr. James Maloney.
Thank you, Mr. Chair. Justice Morrow, congratulations. I was very pleased to see the announcement of your appointment. I practiced law for many, many years in Toronto before arriving here in Parliament. My only claim to fame with respect to the Supreme Court was responding in writing to a leave application, which I was successful on. So I will leave it there. So I'm not going to talk about the Supreme Court. I'm going to talk about the role of the judge generally. Because one thing that's overlooked, in my opinion, for people in your position or the position you're about to take on is the human element. Because judges are people too, after all. And I say this coming from a place, when I was 11 years old, I was living in Thunder Bay. My father was appointed to the Supreme Court of Ontario, which required us to move to Toronto. And everywhere I went, I was the son of the judge. He was my dad. It was that simple. So there's a dual role. There's two hats that you wear sitting in your position, because you're a spouse, you're a parent. You've spoken about your parents and the influence they had, and you've talked about your siblings. But there's a mysticism surrounding the position of being a judge, and you're looked at it a certain way in society. And we're in a room full of lawyers and political staffers, but law students. So maybe you could expand a little bit on that human element of sitting as a judge for 29 years while raising a family.
Wow, I mean, that's I have to try to reflect on the ups and downs of being a parent and being a judge. I know that I was busy picking a jury when my husband suffered a health setback one morning, and there were 200 people waiting for a jury selection at the office, and I had to bring him to the hospital and trust that he would be taken care of, because I had that other job to do that I couldn't hand off because I was the seized trial judge. So there are also sacrifices that you make, and you like to think, though, that in cases where you're really needed at home, you're going to be there. That was a big challenge for me. I think we look back and we say, was I there enough when you have a demanding job? But one thing one of my sisters told me, and it stuck with me, she was an at-home mom, and she watched me with the kids and said, "You seem to enjoy every minute, and you laugh a lot with them." And I say, well, I get a kick out of coming home and changing gears. And I think we all need to do that. But I also think that how I am as a human being does influence how I am as a judge. I'd like to think that people should be treated the way I would expect to be treated, and expect my kids to be treated who are now adults. So I guess it's all part of who I am. And I don't know that one lives separately from the other.
That's very helpful, because I don't think people realize the challenges that you face in your role. Because I can remember my father coming home in the middle of a heavy-duty murder trial and asking me how school was and taking me to hockey practice, and those things are important. Because there really is a powerful human element that people don't understand. So I'm running out of time, so I'll ask this question: how would you like the public to perceive you and you generally, judges at large, in their role as such an important part of our society?
Well, I mean, the word that comes to me is fair. If a person feels that they can't actually agree with what the judge did, but they understood it, and there was an element of fairness in how the judge arrived at their decision and the decision itself, I think that's what people, they take comfort in. Because there's going to be often cases, somebody who is not happy. Most cases, there'll be one person that's not happy. But if they felt like the court treated them respectfully and fairly, I think that's the legacy for us that we should work towards.
La sénatrice Mobina Jaffer.
Senator Mobina Jaffer.
Justice Morrow, it is such a pleasure to welcome you here in Ottawa, and I come from British Columbia, so it's a great pride to have you come from the West, and we know that you will be looking after the interests of the West, so it's a real pleasure to welcome you here. I want to read something from your questionnaire. You commented in your nominee questionnaire that the role of the Supreme Court Justice includes keeping in mind the longer-term interests of society, including the promotion of equality, and this connection highlighted the roles of justices in countering myths and stereotypes. We are now living in I'm extending it from what Senator Clements said. We are now living in a very diverse Canada, and there are so many issues to look at to keep our country together. I'm always worried about many of us are cutting our country, but we really need to sow it. And so, can you expand on what you meant when you said that?
Yeah, I think that just don't want to repeat myself from earlier comments, but the role of the Supreme Court is unique. As a trial judge, I'm concerned about the parties before me. If it's a private action, the contracting parties. If it's a criminal action, the accused, the victims, etc. The Supreme Court of Canada, and I guess we could say of our appellate courts, they have to look at the longer-term implications because they lay down the precedents for our trial judges to follow. And so if you don't do that, and I talked earlier about spinning the prism, if you don't look at all of the implications of a particular direction you're going in, it can be it may be unhelpful to society. And so I think it's a huge role. I wanted to recognize in my questionnaire the responsibility of that office, and I guess my indication that I would take it very seriously. So it's the building incrementally in particular areas with the evolution of society, taking it carefully, one step at a time. And I think that's what I meant.
Thank you. I'd like to go further on that, if I may. Today, the Human Rights Committee in the Senate released a report on Islamophobia, and it had lots, we did not hear very good things, and I want to talk about a woman in hijab and we heard how she doesn't feel heard in the courts or anywhere, and I'm sure, oh, my time is up, sorry.
You still have 50 seconds.
Oh, sorry. So it's, so, how do you make a woman that's not, does not feel she belongs, or a man, doesn't matter, or a child, you will not meet people like people now, in the sense you won't have witnesses, but how, as a court, would you envisage to make a person feel comfortable that they are part of the Canadian justice system?
Well, I think I've mentioned already that the treatment of witnesses is very important, with dignity, with respect, giving them time if they need time to heal while they're giving evidence. Those are all signals to them. I know the other day my last official act was a sentencing, it was a bail application actually on a very serious case. And the accused was having difficulty, some health difficulties. You don't ignore that. You actually address them immediately, and then they feel that they're being valued. It's a small example, but I think that it's incrementally like that we can build respect. And I would expect every judge in my court in Alberta to take that time, because it's not about turning the wheels of justice quickly. It's about making, as I said, the process fair and make people feel like they're valued. I think that's about all I would say about that.
We'll go now to Elizabeth May, who is attending virtually.
Merci, Monsieur le Président, et merci à tous mes collègues, et particulièrement à Madame.
Thank you, everyone, and I would like to say hello to Justice Moreau in particular. This is an important and historic moment, and as a former lawyer myself, I am so pleased about this.
Colleagues, former professors, and student friends from my Dalhousie Law School days. So hello to all. What an honor, Madam Chief Justice. I have been reading your decisions, and I have to say I completely concur and agree with the comments from my friend Marco Mendocino, that in reading your judgment, it is exactly as you say, plain speaking, accessible language, very clear. Congratulations. I may miss Lord Denning and Bluebell time in Kent, but who needs it? We want people to be able to understand what the court is saying. So, ma seule question, c'est sur la question.
My question is a question about Canadians' trust and all citizens of all democratic countries in the world, their trust in our institutions.
Struggling democracies have a problem. I think all democracies, our own included, in people wondering if they can trust their institutions. You mentioned you'd have more to say on that. I'd like to give you that opportunity now. Merci mille fois.
Merci beaucoup. Alors,
Thank you very much. In French or in English, what would you like me to answer in? You spoke both as well. It's up to you. Thank you for this opportunity to talk about this, because my work internationally has shown me how fragile the rule of law can be. I learned that in a number of countries, and I also see it in the Canadian context, that you can never take it for granted that the rule of law is truly cemented firmly. And because it does take the trust of Canadians, and so when you are there could be a judge in a given courtroom, and there could be a citizen in that courtroom who does not act respectfully, and then it goes both ways. It can affect the judge, it can affect the person in the courts. And there has to be a lawyer who intervenes as well. And I know that there have been difficulties throughout Canada that involve this lack of trust and respect in courts. So we have to foster trust. And I think that communication, and as you said, judgments that are written in plain language and that are understandable by Canadians, that are logical and that meet the requirements of the case, all of that helps to build confidence in the rule of law. And really, it's not something that you build and you're done. This is an ongoing thing in Canada and elsewhere.
Merci.
Thank you. And thanks again. I don't think I have very much time left, but thank you so much. It's wonderful to be able to speak with you now, and I have a great deal of confidence in you as a Supreme Court Justice. Congratulations.
Last but by no means least, Ms. Anju Dillon.
Merci beaucoup et félicitations, Madame la.
Thank you very much, and congratulations, Chief Justice Moreau. Your remarks were stimulating and fascinating, and your answers to questions as well. You answered quite a few questions, but just in case there's something that my wise colleagues did not ask, I would ask you to give an answer that would be inspired by your own experience. Before that, though, I would like you to talk a little bit about a case from the past that for which you were a judge. Was there anything that happened that really struck a chord and that had an emotional impact on you or your life even? Could you talk to us about that and share that story with us? And please take all of my 4 minutes for for your answer. And perhaps one day I will make arguments at the Supreme Court with you on the bench. So with regard to your second question, yes, I do recall a very touching moment. I was a trial judge for very serious cases of murder with a judge and jury. And at one point, there was a young man who appeared before me, and he was accused of breaking and entering into a house. And so it was a fairly serious crime, but not the most serious. So he had the opportunity to speak to the court before sentencing. He was so eloquent. He was a young Indigenous man who had suffered a great deal. His family had suffered a great deal. It was before the Gladue report, and he basically gave me his own version of the Gladue report, and I was moved by his story. And it still affects me today. I've seen a number of cases, but that one really drove home the point to me that everyone has his or her own story. And then you also asked whether I had anything to add. I think I spoke a great deal. I have spoken a great deal. And I think that perhaps I have about a minute left. But I would like to say that I would like to assure you that thanks to my long experience as a trial judge and my experience as Chief Justice, which adds a bit to that experience in this sense, which is that I really had a chance to cooperate, to be collegial, to find a consensus, working with other judges throughout Canada, also on the Judicial Council of Canada. So I can assure you that I will use all of that expertise, or experience rather, for the benefit of the Supreme Court. My experience is general in trial courts, but I hope that I will be able to contribute my experience as in criminal law and my expertise in that area with regard to subjects such as issues related to evidence that have not yet been discussed. So I think I have something to contribute, despite my experience of almost 30 years. I also have a lot of energy, and I hope that that will get through as well. Thank you very much. Thank you, Chief Justice.
Donc, ayant maintenant terminé les questions, j'invite.
So now the questions are now over. So I would like to ask the Chief Justice to take the floor once again for her closing remarks. So I think I just did make my concluding remarks, but I hope that our exchange has helped you to know me better and therefore will help with the outcome of the process for appointment to the Supreme Court. Thank you very much and have a good evening.
And so that brings this hearing to a close. Thank you to all parliamentarians for your participation today, and to all those present in the room for your attention, and to all Canadians watching us or listening from coast to coast to coast for your interest in this very important process. Madame la Juge en Chef, je vous remercie de votre participation.
Chief Justice, thank you for participating today. I would like to congratulate again and wish you a great deal of success. Thank you. Good evening.